Well, welcome. Welcome to this webinar on the proposed SEND reforms. Those are set out in two documents, which I'm sure you'd have seen and had a look at. So that's the white paper, Every Child Achieving and Thriving, and then there's a specific SEND consultation document called Putting Children and Young People First. I mean, personally, all these proposals have slightly dated me because when I started practice, we were just coming to the end of statements and possibly of relevance going forward, school action and school action plus. Just to see a whole regime change, I think, has put me in a certain category of practitioner. Turning to the proposals, then, there's been a lot of talk about the rights and wrongs of them on various platforms. But here we're trying to analyse them more from a legal perspective. And we do that bearing in mind that these are proposals. It's a policy position set out by DFE and it's subject to consultation. Parts may make it into legislation, parts may not, may be dropped altogether. And as a lawyer, you're always trying to drill into the details and figure out how things work. And there's a certain tension between that and a policy paper, which is necessarily to an extent high level. But we will navigate where we can and join the dots as we are able. So we've got three speakers today, and we're breaking it into three chunks. We've got the future of EHCPs and the new packages. We'll then look a bit about placements and transitional arrangements, and then lastly, look at the changing role of the tribunal. And we'll try and finish within the hour, but we've got a bit of flexibility at the end if we need it. Just a couple of housekeeping things. Your microphones are on mute, so you don't need to do anything on your computer. There is a Q&A box, and we welcome questions throughout the session, and we will try and answer as many of them at the end as possible. There is a box to tick if you want to send the question anonymously, if you prefer to do that. The webinar is being recorded, and you will receive a link to the presentation at the end, or probably shortly after the presentation concludes. And if you do lose connection at any point, please just log out and then log back in, and that hopefully should fix things. So moving to our first speaker, Joe Thomas. He practices across public law with specific expertise in education and special educational needs matters. He acts for parents, local authorities, and he's on the government's panel as well. And he'll be looking at the future of EHCPs and the support packages that may come forward. So, Joe.
Thank you. Good morning, everyone. My hope today is to take you through what the overall package of proposed changes is, and then as I've gone through, I've tried to comment on potential issues that pique my interest as a lawyer, because we're always interested in the exact tests and definitions. So the proposal, as I'm sure you're aware, is to replace the structure as it stands at the moment with additional layers of support. And what they're going to look like in practice is not entirely clear at this stage. I think the first point to note is I'm sure you're very familiar with the diagram that's been put up on the that comes through the documents. But the first point to note is that whilst considerable focus has been put on additional support will look like, the white paper itself actually emphasises that most children, even with SEN, will not need additional support, i.e. the universal offer is intended to cover the vast majority of needs. Now, whether or not that's realistic in practice is going to play out. At page 50 of the white paper, it says at the heart of this vision is a universal offer of high quality teaching support for all from early years to age 25. So it's emphasising that the additional levels of support, targeted plus and specialists, are for the minority of children with SEN. It is meant the focus is meant to be on upskilling and up-resourcing the level of support available from that universal offer. So again, at page 50, it then states, in practice, this means commonly occurring needs, whatever that means, that every school should be familiar with, can be consistently met in mainstream education through adaptive teaching, calm environments, and enrichment opportunities. We are not asking teachers to teach differently or to work harder, although that does sound exactly like what they are asking teachers to do. And so obviously my first question arising from that is, what needs qualify as commonly occurring? Does that, for example, extend to young people, children and young people with ADHD, oppositional defiance disorder, autistic spectrum condition, and to what severity does it extend to? So the overarching purpose is that we expect most children and young people will have their needs met through this universal offer. But at this stage, it's not entirely clear what they consider to be commonly occurring needs and severity. And I think the statement that we are not asking teachers to teach differently or to work harder or to take on greater responsibilities doesn't seem completely reconcilable with that aspiration that the universal offer will improve materially. So we then move on to what is meant to be for a minority of children with SEN of targeted and targeted plus. Targeted is for children and young people who need additional help to access education. Support will be organised across 2 additional layers of support: targeted, including targeted plus, and specialist. And I pause there to note that targeted plus is meant to be an enhanced version of targeted, and it emphasises that in the white paper that the difference between targeted and targeted plus is in question of degree, and it's not a category difference. And it seems to be focused along the level of support that will be provided. So targeted plus, it seems to be required that if that young person is then going to access what is to be known as a support base, they will need to be eligible for targeted plus. And targeted plus will require input, whatever that means, from education and health professionals. So I pause there to just note, again, as a lawyer, I'm interested in definitions and thresholds. And as far as we can tell, there isn't a particular threshold or definition that's laid out in the white paper about what those level of needs are that are going to make a young person eligible for targeted, including targeted plus. Further, at this stage, it doesn't seem particularly clear about what form that input is going to take from education and healthcare professionals. Does that mean direct provision, i.e. the occupational therapist coming in to make that provision, or designing the program? And bearing in mind that we are meant to be upskilling these support bases, it does seem that those schools are meant to be able to offer that targeted intervention without reliance on external professionals. But whether or not that's going to work out in practice, again, is still not entirely clear. So we then come on to, what does that mean for the young person? So targeted and targeted plus and specialists will have an individual support plan. And we had a useful discussion earlier amongst us about, well, are these meant to be generic documents? And I think the very phrase individual support plan means it's going to have to be tailored to the young person. And at page 54 of the consultation, it says these plans will capture barriers to learning day-to-day provision as opposed to extraordinary provision or monthly provision or termly provision, any reasonable adjustments and intended outcomes. And as the aspiration is to bring even more children into the mainstream environment, we're anticipating that there is going to be more and more discussion about, well, what is a reasonable adjustment for this school? And if there is going to be any additional funding so that schools can make physical changes to schools or bring in additional staff. What I've noticed is that individual support plan, which is meant to be negotiated and prepared in collaboration with parents, does not appear to be required to be informed by an equivalent to an EHC needs assessment. So it doesn't look like there's going to be a formal process, as far as we can tell, for the preparation and publication of an individual support plan. It's going to be a more dynamic, informal process. What we do know about duties is that it's going to be the duty on the school to produce an individual support plan for every child with SEND. Not entirely clear how that squares with the expectation that universal offer will meet most needs. So are we saying the individual support plan will say you will be met by the universal offer? Will this involve a redefinition of SEND, or will the term generally available under Section 20 and 21 be expected to reflect that there's a baseline of an improved universal offer? Again, it's not entirely clear at this stage about how that will manifest as legislative changes. We know that the ISP is going to be updated every year, which obviously has implications for the level of paperwork and the level of work required by teachers, particularly SENCOs. It's not entirely clear what the legal status of that ISP will be. Is there going to be an obligation on the school to use reasonable endeavours to deliver it? I'm certainly not expecting any equivalent to the EHCP where you must secure. Who is going to enforce it? Is it going to be parents? And then what mechanisms are they going to have at their disposal to enforce it? How will disagreements about the contents be resolved? At page 47 of the consultation document, it says the duty is to record and monitor provision, not secure. And talking to colleagues before, we've both recognised that there is often, when parents and local authorities and schools are negotiating an EHCP, there is a tendency for these documents to become longer and longer and longer as every single concern is listed, and that undermines their utility. So we think there might be a real risk that there's going to be a tension between their utility and the desire for all of that information to go in. And if a school, and it's not entirely clear what the process is if there's going to be a disagreement about the contents of those ISPs, and whether or not there's going to be any third party involved in adjudicating on those disputes. Coming back to that difference between targeted and targeted plus, we know that targeted plus is going to involve the greater use of support bases. What they're collectively known as inclusion bases, and these are going to take on two beasts: support bases, which are setting or multi-academy trust funded, and they're going to be providing targeted support. And then we're getting specialist bases, which are LA funded, and they're providing specialist support. So again, we're going to get additional questions about what duties are emerge, as into who's responsible for funding these, who's responsible for placement, because as I'm sure you're aware, there's often you can't place a child in that EHCP in a especially resource provision. Is the white paper anticipating a change to that so that you would get a school within a school named in an EHCP? An interesting question I haven't seen the answer to. One thing that I'm anticipating that is a difference, and is going to be quite actually maybe underestimated at this stage, is if we are expecting schools to be delivering an equivalent of EHCPs, the ISPs, and it's only in the most complex or severe cases that the duty is handed over to the local authority. At the moment, when there are conflicts, schools are often on the side of parents saying, oh, actually, we need more provision, we need more need, we're doing our best, but we need the local authority to step up. But under this scheme, where more and more responsibility is placed on schools, we're going to see a really different dynamic emerge, where the parent is having to dispute with the school rather than the local authority about what provision that young person is entitled to, who decides, what evidence is used to decide that, and is it being delivered? And at the moment, the dynamic is you often get an alliance between parents and schools, but I think we can see actually more divergence between parents and schools if the pressure is to put the responsibility far more on the schools. And I think that's possibly an element that hasn't been reasoned or thought out, and could have quite a different character to the situation at the moment. And then finally, we get to the specialist level of support. the headline point is that fewer children will be entitled to specialist level of support. Most children's and young persons' needs are meant to be met without specialist support. The other thing to note, notwithstanding that most young people are meant, it's only for the most extreme, complex, and severe needs, is specialists are still meant to cover provision provided at mainstream schools. So specialist support does not equal a specialist school. As far as we can discern a test, as alluded to within the white paper and the consultation document, the test appears to be you will only be eligible for an EHCP where you're entitled to or need provision which is substantially different from the usual curriculum model and approach delivered in mainstream settings. It's not clear whether or not that test is going to be delivered through an update to the test of necessity in the present Part 3 of the Children and Families Act, or whether or not that test is going to come in indirectly through guidance to update what is meant by necessary. These packages of support will be known as specialist provision packages and will underpin the provisions set out in EHCP. Again, what does underpin mean in practice? Are the EHCPs going to copy the standard content of a specialist provision package, or are they merely going to refer to it, or are they going to say we're going to take these elements, but we're not going to deliver these elements? It's not entirely clear. We do know, however, that these specialist provision packages, which are meant to anchor EHCPs, are going to be reviewed and informed by expert bodies, and that's meant to deal with the issue of parents always appearing to have to fight for provision, there not being any sort of external benchmark about what is reasonably required. We do know that it is only going to be those that are entitled to special provision packages who will be entitled to an EHCP. We do also know that an SPP will set out nationally defined evidence-based support for children with the most complex needs, not just complex needs, but the most complex needs. So again, we're seeing that the eligibility for EHCPs is being narrowed further, and ensuring families receive clearer and more consistent entitlements. So there is going to be some anchoring and evidence basing, and there is meant to be something equivalent to a sort of national standard of what reasonably required looks like. We've got a lot of questions about, for those who don't fall within those models of an SPP, the white paper indicates that there is going to be bespoke EHCPs and potentially regional funding commissioning for the most extreme and complex needs, but we're also not entirely clear about what that means in terms of for EOTUS, what this means for the test. Is it going to be severe and complex, or is it going to be a variation of necessary? Does this programme, which does include Ofsted rating of inclusion explicitly, which is going to be a new heading under the Ofsted framework as we understand it, but does that still mean there's going to be this perverse incentive that for a school to get more funding, more support, they've got to demonstrate through failure that inclusion doesn't work? And I'm not quite sure that the programme as it stands at the moment actually removes that incentive. And then given the variety of needs, will these model SPPs become a straitjacket rather than a starting point? At this stage, these are questions rather than answers, but at the moment, it doesn't quite clear that every single tension has been fully resolved. At this point, I've got the pleasure of handing over to Katharine, who's going to talk about how that manifests, all of those issues manifest in terms of placements and what the transitional arrangements look like they're going to be. Thank you very much.
Thank you very much, Joe. And as Joe has said, we'll be handing over to Katharine to talk about parental preference and transitional arrangements. Katharine is another very highly rated barrister here at Landmark. She practices in SEND education as well as related areas like court protection, health and social care. And so I'll hand over to Katharine now to talk about that.
Thank you, Leon, and good morning, everyone. So in terms of placements, I think from the white paper and from the consultation paper, it's clear that there are I think, three main reforming principles that are involved, which obviously align with those that Joe has already addressed in his talk. The first is mainstream inclusion. So there is a definite drive towards ensuring that as many students with SEND as possible are educated in the mainstream environment. That taken together with the drive for children to be educated in placements local to their area, and alongside both of those things, value for money as a major consideration. So, in terms of mainstream settings, Joe's already dealt with what that would look like. So, the creation of inclusion bases, support and specialist, plus increased external professional support, plus what they refer to as time limited specialist placements. And what that seems to be is giving students who are in mainstream placements a sort of time out in a specialist environment for um, using a slightly clumsy term, upskilling. So, if, for example, you have a child transitioning into secondary school and they're finding that transition difficult because they have high levels of SEM need, they might be sort of introduced into that environment via time in a specialist placement where they can be assessed, supported by specialists to have particular techniques or assessments that inform how they are supported by the teachers and other professionals in their mainstream placement. And then we have the specialist setting, which is only for, as Joe has already explained, those with the specialist provision or SPP, which would then lead to them having an EHCP. So I think a key change is that all settings, whether mainstream or specialist, so independent placements, will be commissioned to provide placements for specific specialist provision packages, which are linked to a national funding framework. So what is envisaged at the moment by the government is that there will be 7 bands of SPPs. We don't know what those will look like. We don't know how much distinction there will be between them. But obviously, the idea is to have some sort of graduated approach from 1 to 7, and that those SPP grades will be linked to a national funding framework. And that will dictate how much money goes with each place. And there is no discussion in the documents that we have seen of any ability to depart from that. So it would seem that that is a set framework that everyone, every setting will have to abide by. So there will no longer be individual costings for SPPs, which are going to be the gateway, as it were, to having an EHCP under the reformed system. And obviously, to be clear, as Joe's already explained, the specialist provision could be delivered in mainstream, but obviously could be, and the paper expressly recognises, could be provided through a private or independent placement as well. And I think it's clear that the costing limits are expressly intended to target those higher cost packages that I'm sure everyone on this call will be familiar with, which involve costings being provided by an independent school over which local authorities currently have no control at all, other than through the exceptions to parental preference, which we'll come on to in a moment. Placements, before we move on to sort of preference, seem to have a much bigger role generally in the formulation of what an EHCP or an individual support plan as an accompanying document will do. The decision order is going to change. So at the moment, obviously, we all know you have your sections A to F, and all of those are always dealt with before you get on to the issue of placement in I. But now what will happen is that the local authority, when it's considering an SPP, will decide whether the threshold is met, then decide what of the 7 SPP bands a child should have, and then based on that, it will decide which SPP is placement from a set list it considers is going to be best able to meet that. And while it's not identified clearly, it would appear that the emphasis is going to be on that list being for local placements. And we'll come on to sort of parental preference in a moment. But I think a real point here is at the settings. So take private SPP providers will be commissioned to provide placements for those specific 1 to 7 bandings, and they'll be expected to organise support in accordance with those bandings for all the children in that band that are assigned to them by the LA. And they will be subject to a legal duty to secure the provision in the SPP and the HCP in accordance with the funding band. So there won't just be a duty on the LA, so the Section 42 duty to secure the provision. There will be a duty specifically on schools to provide that within the funding. So just as local authorities currently have the issue of being in breach of the mandatory Section 42 duty because they can't afford, for example, to get the relevant experts in, or there are no experts, you will see schools under the creation of this new duty, subject to any carve out that the government might make, being in the same position potentially, where they can be potentially taken to court on the basis of breach of statutory duty. And if their argument is, well, there isn't enough funding, if the duty is as currently envisaged, the court's answer would be, well, you have to deliver that within the funding that you're given, and that's mandatory. So comply with it or continue to be in default. If an independent placement declines to accept the new funding bans, there is going to be, as currently proposed, the power for the Secretary of State for Education to make decisions about the future of those placements. So to refuse to allow independent special schools to expand, and to decline to allow new ones to be opened where there's limited evidence that they are basically meeting the demand for SPPs from commissioning local authorities. And that will mean that they can't register as an independent special school, they can't provide SPPs, and they can't receive state funding. Now, that's obviously a very significant change for independent placements, given the prevailing situation that we're all aware of, and one where I think all of my colleagues on this call agree that there's a significant risk of legal challenge to the government once it's set out what the national funding framework actually looks like. For example, under Article 1 of the first protocol, which is the right to enjoyment of your possessions without interference, because obviously it's a bit of it's a stick, but I don't think there's much of a carrot as a stick reform. So you independent special schools will accept this funding arrangement. Otherwise, we could effectively, we will be significantly curtailing your ability to operate and therefore make money. And the government itself, I think, is quite aware of the interests at play in the independent school sector, because, for example, in the consultation paper, it goes into a lot of detail about the fact that there's a lot of private investment, interest, hedge funds involved in these. So they are clearly aware and want to effectively target the profits that are being made by those companies. But obviously, the fact that there are profits being made is a strong incentive for any challenge. So the government's going to have to be very careful about how it approaches that funding framework. And for example, whether it wants it to be truly national or whether it wants to take into account any regional variation for different types of special school and so on and so forth. I think it's very important from my perspective that this is not a tax like the VAT that went on private schools, where there is effectively recognition in human rights law that the government of the day has a large margin of appreciation. Effectively, it can tax what it wants. But in this context, it's a commissioning package. It's payment for a service. So I think there'll be a much greater scope for these challenges because of the law and also because of the financial incentives for such challenges. So I wouldn't be surprised if when the government actually sets out how that framework will be done or specifically or its methodology, whether there will be some sort of legal challenge on that. And generally, settings will also lead on description of the provision in the EHCP, which will be based on the SPP. So as I said, the SPP will come first, then the EHCP, and then the ISP, and the placement decision will be made after the SPP has been identified. In terms of duties of public bodies, I think we had a question in the chat, which I'll deal with now, about is there a risk about having conflicting mandatory duties belonging to different public bodies? I absolutely think there there is a risk that there will be a conflict between them, because, two mandatory duties that are both attached to funding availability when funding is tight, that is linked to sort of legal liability and the possibility of being sued. I do think there is a significant risk of the Section 42 duty as it is or is modified conflicting with this new duty on placements. And I think we might find ourselves in the situation that many in the family law or court of protection law see, for example, ICBs and local authorities fighting about who has funding responsibility, where the law hasn't made it particularly clear who takes priority. So that definitely is a problem that will have to be hopefully addressed by whoever's drafting the legislation. So moving on then to parental preference. As I've said, the local authority with expert input, and Joe has flagged, we don't quite know what that means, will determine whether the child meets the threshold for the specialist provision, and if so, will identify which of the 1 to 7 SPP bands will be best suited to them, and then a placement from a list of presumably local options. And then you have the right of the parent or the young person to express a preference that runs contrary to that. And the consultation paper makes it clear that where a change of settings is necessary to deliver the SPP, so that's not just, mainstream versus ISS, but, different mainstream, different independent placements, that right to express a preference it applies there as well. The system that appears to be being envisaged is actually not too dissimilar when you read the papers from what we have now, as in it differentiates between mainstream and specialist settings. So it will remain the case that where a parent or a young person with an EHCP indicates a preference for a mainstream setting, there'll be strong legal duties on the LAs to make this happen. Now, why am I saying strong duties in air quotes? Well, a duty is either mandatory or it's not. And the duty would appear to be mandatory based on the wording. So I'm not quite sure what strong means, unless they are intending to sort of strengthen the sanctions for breaching it. But beyond, the ability of someone to sue for failure to comply with the statute, I don't quite understand that. So hopefully that will be explained in due course. But treating it as a mandatory duty, it would seem to be the same as Section 39 of the 2014 Act is now. It will be subject to that preference to the existing legal exceptions in Section 39(4), for example, that preference would be incompatible with the efficient education of others. But there will be additional exceptions. For example, that local authorities are not required to name a school where it's already full, or where, to use the wording in the papers, this would have a seriously detrimental effect on pupils already there. Now, the already full is quite a significant departure because, as most people on this call will know, under Section 41, a placement at the moment has a duty to admit regardless of whether the school is full, and children with EHCPs are not counted in the classroom limits for schools. So it appears from the wording that if a school is full, i.e. a popular school where children with SEND do well, you won't get in. So that is going to be a problem, particularly in very densely populated parts of the country, or sparsely populated parts of the country where SEND provision is not as good as in others. I used my air quotes again. I probably do need to stop doing that. I've just moved a slide too early, so I move back. But there's reference to seriously detrimental effect. And it's unclear to me to what extent that differs from incompatible with the efficient education of others. So hopefully there'll be some definition, some flesh put on the bones of that reference. So that's mainstream. So effectively the same, but with more exceptions to apply. And then in a specialist setting, again, it seems to be pretty much the same. So the local authorities will provide parents and young people, as I've said, with a list of settings able to provide the SPP, and parents will have a right to choose any of the settings on the list or express a preference for an alternative. It's not clear to me if there's any difference made, say if it's a list, so, is that going to be any easier to get for parents than if it's an alternative that's not on that list? Again, some thought will have to be given to that. And then as currently under Section 9 of the 1996 Act, the decision about placement the LA makes is then made based on that preference as a material consideration, as well as all the other things, which include effectiveness, good value, and the needs of other children. So again, the same sort of exemptions as currently apply under Section 39. And it's not clear, sorry, Section 9. It's not clear whether there's going to be additional exemptions to that as well, but I presume that they'd want to make the exceptions consistent. The most significant change to the exceptions for both regimes is going to be amending the legislation related to incompatibility with the efficient use of resources. So, what I would call the costs issue. And it says to make it clear that weight must be put on the evidence of the effectiveness of the provision, value for money, and the fairness of future decisions about placements. Now, this is very woolly wording at the moment, but it's clear that they want to strengthen the weight that can be given, at the very least, to the fact that some placements are incredibly expensive. And that's clear because one of the examples they give is the LA considering the impact of making a single high cost placement in a special school on the ability to meet the needs of all children and young people in the area. But it's going to be very interesting how this legislative reform is worded, because if they actually want to change this and address the issue of local authorities being in default of their Section 42 duty, or schools under their new duty, and have more consistency in decision making around costs, I think they probably do need to go further than just being a material consideration, because as things currently stand, different decision makers have a very different appreciation of what cost means, as do parents. There are also obviously other areas of uncertainty which are in the current system. What resources can be taken into account? Is this just the local authorities, or is it more broadly? And also to deal with the issue of transport costs. And that's something that the government is clearly very concerned about, because the image of a child making a long and expensive taxi journey is front and centre of quite a few of the documents I've seen, including the consultation paper. So to draw this slide to an end, I think parental preference is still applying in the same way. But the exceptions are going to be beefed up, in particular around costs. And to make it clear, I think, because we had a question in the chat, it seems that parental preference, the rules would apply in the same way that whether you're levelling up or down. So if a LA says, well, you need an SPP, and the parent says, well, no, I don't think my child needs this, and they should be in mainstream, not in a special school, the local authority would apply it in the same way. Obviously, the issue is that the difference is cost is less likely to be an issue in those situations. So moving on then to transitional arrangements. These are fairly simple. So until September 2029, there will be no change. And that is because the legislation will not be in effect until that date, if it is even in place by that date. I think many of us will be aware from other areas that there have been reforms that have been promised, even legislation that's been debated, and absolutely nothing's happened. And we're also all aware of the demands on parliamentary time. So that's the target date of September 2029. After that date, when the legislation has come into force, making all the changes that Joe and I have outlined, all existing EHCPs will be reviewed at transition points, which are end of primary, end of secondary, and post 16. So the standard pinch points for special educational needs decisions, to determine whether an SPP is required. So whether you fall into one of those 1 to 7 brackets. And then all existing EHCPs in place will be there until the academic year starting September 2030. So the academic year after this review process has happened. It doesn't take into account that there might be delays to the reviews or appeals or anything like that, but hopefully that will be dealt with in more detail later. But I think very importantly, the provision is that no child or young person will be asked to leave a special school, so an independent placement, as a result of any review. They can stay there until the end of their education. Now, that must have been quite a difficult decision for central government, because they are the expensive places and they are the ones that hit the headlines for people who think the system needs to change for financial reasons. But I think from my external view, it's actually quite a pragmatic policy decision by the government, including, I would presume, because they're aware of the possible legal risk of removing children who would count as many of them disabled for the purposes of human rights and disability discrimination law, that, if you remove me and put me somewhere else, especially if you've been in a special placement for a long time, because you are reforming the national system as like a broad brush measure, you could see in Article 2, Protocol 1, so that's the right to efficient education challenge, including taken together with Article 14 or other types of legal challenge. And they clearly were aware that that would have been an incredibly unpopular result of it, and likely to garner lots of opposition. So that seems to have been a pragmatic policy decision there that they've made. And then the transition will be overseen by the Children's Commissioner as an independent body. I think my concluding view before I pass on to Fiona via Leon is I think we can safely say, given what the transitional arrangements are, that we will see a huge scramble of appeals against decisions with parents seeking to secure specialist placements now, between now and 29/30, because once they are there, they will be guaranteed to stay, which is very important. So I think this is one of the things that leads the government to say there will be no significant financial improvement in the current system until about 2035, because obviously there will be all these children who will have their placements and will retain them under the proposed changes that have been set out to date. And that is the end of my talk. Thank you very much for listening, and I'll hand you back to Leon.
Thank you very much, Katharine, and thanks for your advice. So Katharine is one of the experts on Article 1, Protocol 1, having spent a lot of last year doing the leasehold reform case on a different area of legislation, but the same article. I should hand over to Fiona now, who doesn't need any real introduction. She is a leading education silk and has been across this, and dare I say, back into the Education Act 1996 regime as well, which I mentioned earlier. And she's going to be talking about putting the SEND paper into context of the wider white paper, as well as discussing the changing role of the tribunal. Fiona.
Hello. Well, if Leon feels old, I feel like Methuselah having this discussion, having gone through at least 3 fairly significant changes to the SEM regime in my nearly 30 years of practice. Oh my God. What I would say about this is I'm going to firstly talk about the changing role of the tribunal, and then I'm going to talk about some general issues to do with redress and accountability, where we as lawyers can perceive either more conflict or a greater likelihood of legal intervention. So firstly, in respect of the tribunal, this has already been the subject of legal action because Rook Irwin Sweeney in the middle of last week issued a pre-action protocol letter against the DFE and are going to issue proceedings on the basis that the consultation document fails to ask any questions about the altering the rights of the tribunal. So you've heard from Katharine and Joe what the changes are going to be to the way that an EHCP looks and how you might get there. If you do then get there, firstly, you are no longer going to be able to appeal just about sections B and just about section F. They're getting rid of that. You are still going to be able to appeal in respect of whether or not there should be a needs assessment to get the specialist support package, but there's no discussion about what the thresholds of that's going to be. Is it still, I suspect it's still going to be, is it necessary? So there is still likely to be, if specialist support packages, I suspect they will be, well, firstly, they're going to be the only way of you getting into a special school on a long-term basis. And secondly, they are likely to be the route into a significantly enhanced package, although these reforms only work if you're looking at a great deal more day-to-day special educational provision being provided in mainstream settings. That's the only way this is going to work, is if you shift the burden onto schools, which is what is explicitly stated throughout the white paper. So you're still going to be able to have appeals about what we would now call statutory assessments, which are going to be assessments. You are still going to be able to appeal about B and F, but only if there's a placement decision as well. And my view is that the current consultation documents totally lacks clarity about what's going on with B and F. It says it will be considered as part of the appeals about specialist provision packages, but you're not going to be able to have standalone appeals. And given that most special educational provision is meant to be in ISPs, you're going to have a situation whereby you're going to be looking at what's in an ISP, what's in the specialist support package and then what's in the EHCP, which is meant to be basically that which is different or additional to that which is in the ISP. So we're going to be looking at 3 documents rather than 1. And this is the most controversial part of the change. You're going to have your list of settings, as Katharine identified. You can appeal, but the tribunal can't name a setting. All it can do is decide, is this decision reasonable, quash the original decision and send it back to the local authority. So in effect, for those of you who are familiar with the exclusions framework, you are doing exactly the same thing as they can do in exclusions. So the tribunal will no longer have any power to name a particular school. That, I mean, firstly, it therefore means that there's going to be all sorts of arguments if you're turning it into a sort of a rationality, what those of us who practice in this area would be to say a judicial review type decision. There's going to be all sorts of arguments about what's reasonable in this context. Should it be Wednesbury reasonable? If you're talking about types of education, should it be a proportionality assessment? I can see all those sorts of arguments coming out, which we don't have at the moment. And secondly, as you can't substitute the name, there is going to be a longer period of time, potentially, especially if there's dispute or significant dispute about where it is this young person is going to go. That is significantly curtailing parental preference rights. And that, plus what Katharine has already said, which I think is only going to work by amending Section 9 of the Education Act, 1996, as well as amending the Children and Families Act, because what they're in effect doing is diluting parental preference by a considerable degree, because you're going to be able to take into account equity more broadly within the local picture when local authorities are making decisions about placement choice. And that is inevitably going to lead to fewer expensive placements. I also agree with Katharine entirely that the A1P1 argument is going to be in play. I'd be surprised if people hadn't already taken advice about it. This is just a consultation, but let's assume for financial reasons, the Treasury is going to want this to go through, given the massive increase in cost that there's been. And therefore, there is a significant potential for there to be a wholesale attack on the changes which are made in respect of parental preference and also the cost capping in respect of special schools. Now, as far as the cost capping is concerned, quite a lot of work has been done by the Competition and Markets Authority about social care costs. And it seems to me the government is pretty much relying upon that work by the CMA, which basically says there's been a lot of unjustifiable price increase in setting those costs, for which there is no independent market. It is really only the state that pays for that, which is where I think the A1P1 argument, I think, will ultimately fail. This is me, looking into the future, and I could well be wrong. But there has not been, as far as I'm aware, the same sort of work done in respect of the cost of independent special schools. Now, it is the case that independent special schools cost about £2.6 billion a year, despite the fact that they are, so that's about a quarter of the budget, the high needs budget, despite the fact that they're only 7% of EHCPs. So there is obviously a cost pressure, but this is driven to drive down costs, which I think everybody agrees have gone up massively over the past 10 years. I mean, you've had significant inflation, which has caused some of it, but it's gone above and beyond that. But I can see there being a number of issues around that. The next issue I think that's going to happen is, as you've already heard from Joe and Katharine, this is all about inclusion in the mainstream. This is all about schools making significantly more reasonable adjustments. There is apparently going to be some more money for capital investment in terms of physical adjustments. But what I think will then happen is there are going to be significantly greater numbers of claims brought under the Equality Act. At the moment, the way that the SEM framework and the reasonable adjustment framework meet is they're meant to sort of interlock with each other. If you've got a lot more going into the school-based provision, I think, and you're also going to have, as Joe and Katharine both said, a sort of school versus parent, there is the potential for that conflict and dynamic, and you're not going to have the option of going somewhere else because your parental preference rights are less. You are going to have greater numbers of parents appealing. Now, the number of cases that go to the first tier tribunal in respect of disability discrimination are relatively small in comparison. I think there's somewhere like 500 or 600 appeals a year, which isn't really very many compared to the 24,000 appeals about special educational needs that go every year. There's a massive disjunct, but I can see that becoming more of an issue because, as everybody has said, there's going to be a much greater incentive or a much greater need for schools to make those reasonable adjustments. So the other area, there are a number of other areas which I just wanted to touch upon. Firstly, school complaints. School complaints are currently a total mess. If you are giving people, or if you are saying schools have to do more, they have legislative duties. And I think it's going to be interesting to see. It seems to me that if they're going to have duties to meet the ISP provision, which is what we're looking at, it seems to me there is going to be the potential to be able to judicially review schools for not doing that in the same way you do judicially review local authorities for not making the provision in the EHCP. So firstly, you've got schools potentially having much greater liability for judicial reviews than they do have at present. Secondly, schools already complain about the significant number of complaints. There doesn't appear to be anywhere in either of these papers some discussion about some kind of independent body in respect of school complaints adjudication, for which there has been quite a lot of discussion over the years, whether or not, for example, the local government ombudsman should take over that, or, for example, the DFE could set up a sort of a complaints body or a complaints mechanism. That doesn't seem to be taken up in the white paper or in the consultation. But what there is at the moment is an idea that strengthens school complaints by having an independent panel member on all complaints. Well, I mean, how are we going to get those? Again, I think multi-academy trust, the idea is meant to be, because every school is going to be a school trust, you're going to have a bit like you have with independent review panels, you're going to have independent complaints panels. But where do you go from there? Again, I can see maybe judicial review for a number of cases, although it's going to be difficult to get legal aid funding for that, and the cost of that. So, I mean, why don't they set up a body, a national body, to deal with complaints about schools? They have also said that they're going to set out some more guidance about vexatious complaints, which is something which I know a lot of schools are very worried about. But what I can see this doing is massively increasing the number of complaints that are made to schools, and therefore the time and the cost that's going to be spent in doing that. I just wanted to raise a couple of other issues which are going to require legislative change, or where there is an issue which is likely to involve lawyers. Firstly, all schools need to be part of trusts. Now, we've heard this before. We've heard this in 2010. We've heard this in 2017. We've heard this, I think, at some point just before the COVID pandemic. It sort of got lost in the midst of the COVID pandemic. New trusts are going to be able to be established by local authorities or area partnerships, which may include health. We've heard all this before. I'll believe it when I see it. But what there is going to be is new trust standards, and trusts are going to be inspected. So there's going to be a little bit more oversight of what goes on within multi-academy trusts. Don't forget various changes which are already being made under the Children's Wellbeing Bill. So there are going to be improved statutory duties for the safety and welfare of children. You've got the Register of Children out of school, and work on more information sharing. Again, what's going on with health? A lot of this SEM work can only work if ICBs put a lot more money into SEM provision and a lot more people into it. The white paper and the SEN consultation recognise that, but I want to see what's going to happen. We need to have a much better degree of accountability from health bodies in terms of their part of the picture. There's lots of discussion about pooled funding, the creation of mental health support teams to all schools. There's going to be a new multi-agency safeguarding teams, which are going to include education. Serious violence hotspots are going to have new multi-agency safeguarding teams, and changes to the school admissions code, which they say they're going to be consulting on this year. Firstly, in order to basically try and exclude buying your way into schools. I can only see that really working if you get rid of physical distance as a core oversubscription criteria and you introduce banding arrangements. The government has said that they're going to provide more clarity about banding arrangements for representative intakes. And it seems to me that they are trying to repivot admissions onto creating, particularly for disadvantaged children, more incentives for schools to take them. Again, let's wait and see. But that's something which us as lawyers are going to have to look about, think about, work out how that's going to impact in terms of any legal challenges. There's also going to be new guidance on internal suspension, off-rolling, and a variety of different statutory mechanisms to try and include this. The last thing I wanted to talk about is there's going to be a national school support staff negotiating body to carry out bespoke negotiations and some additional money and professional development work for teachers. My view is significant dilution of the tribunal's powers, significantly greater focus on inclusion, significant dilution of parental preference, likelihood of increase of Equality Act claims, and a lot of well-meaning guff to try and make things better for the most disadvantaged in our society. I will believe it when I see it. Okay, I think it is now 11:58. Are there any questions, Leon?
Thank you very much, Fiona. Yes, we've had quite a few questions. I'll try and group them into bits. So one of the things that came up earlier was in relation to what does it mean when a school is full, and can a school engineer the number to decrease pressures? And I think that the short answer, I think, it's not really been worked through. From my perspective, I think it's addressing the situation where usually a very popular school is completely oversubscribed, and they have requests for so I've had a school where there's been 10 requests for placement, 5 of which are going to tribunal, and the tribunal is then using the test of whether it's incompatible with the efficient education of others. And you get all these plans of how big the classrooms are, and there's lots of this evidence, but they're only considering it for the one student without an eye on the fact there are 5 others coming down the line, and the school gets squeezed. And I think the idea is that you end up having, with more placements, with more provision, the idea that shouldn't happen anymore. Fiona?
Yeah, I think this is particularly in response to the special school crisis in special school placements, because I think the research shows that there are a significant number of special schools who are massively overnumber, and there has been a real pressure on that. And that, I would say, is because there hasn't been capital investment in increasing special schools, but certainly in a lot of areas, special schools, you could have 40 appeals for a mainstream special school maybe in the course of a year. That's, for a lot of these schools, that's almost doubling their numbers. And that's where I think partly you're talking about the reduction in parental preference. So if it's full, you can't get in. And it seems to me full is going to be based on the planned admission number, the PAN. How many people? And obviously your PAN, if you've got a lot of wheelchair users, you've got kids with PMLD, is bigger than a mainstream setting. But on the other hand, if you've got more specialist children with those kinds of needs in a mainstream school, does the PAN need to flex to think about that? Because the planned admission number at the moment is literally like a sort of square footage. Everybody gets like 6 foot by 12 foot or something per pupil, but different children need different amounts of space. So I think, you know, you might want to think about the PAN if you've got practically everyone in a mainstream school, which is definitely where the government is headed.
Yeah. We've had a few other questions, again by theme, on the reasonable adjustments and possibility of increasing numbers of discrimination claims in the tribunal. I mean, do we think, Fiona, I mean, this was your point, do we think that's really going to follow through in the legislation? Do we really think the government is intending that suddenly these are all litigated through the Equality Act? Surely, well, probably not, but...
Well, they're definitely talking, well, I mean, I don't think they want there to be more claims, but it seems to me clear that they are shifting the expectation of what a mainstream school provides significantly in the direction of it being met without the need for an EHC plan. And it is shifting through the creation of the expert at hand, a lot more specialist provision, and the creation that every mainstream school, secondary, I think, no, actually every mainstream school has to have an inclusion base. Once you are doing that, you are constructing a system whereby the reasonable adjustments you as a school are expected to make are going to be significantly more onerous, or what is considered to be reasonable is going to be a much higher amount of adjustment. And therefore, particularly if you've got parents asking for ISPs, there being questions about what's in an ISP, I can see that being the source of conflict. And therefore somebody saying, this isn't in an ISP, I'm going to complain about this. I mean, there's no mechanism at all to go to the tribunal about this other than via disability discrimination. So that's where it's going to come into force. Now, at the moment, relatively few parents use the reasonable adjustments, use the tribunal. And I'll be honest with you and say it takes ages. It's really quite complicated. And for schools, furthermore, it costs a lot of money, and for parents. So, but I can see, because you're not going to have other routes, that being the route that parents go down. Sorry, I think that was probably quite a boring and long-winded answer.
Well, the resources bit's quite interesting. So you mentioned money, but money in a different sense, because at the moment, when you're looking at Section F, whether something's reasonably required inherently considers what the cost is, but it's very much an unspoken point at tribunals. Money, the resource implications of a particular provision aren't hugely talked about in Section F, at least. But I think when you get into the reasonable adjustments arena, I think schools are more willing to say to talk about how this fits into their overall resources, at least, I think.
Yeah, well, they will, and there's going to be, but I think the tenor and tone of the white paper is there's going to be national guidance about what's expected. So I think firstly there's a focus from individual variation to basically national systems of support. So there's going to be, this is what we expect you to do nationally, this is what we expect to be in ISPs, this is what we expect to be in SSPs, these are the baseline, this is the money that comes with it. And therefore schools are going to be expected to meet those. So therefore, if you want to have them, the question is you have to make sure that what the government produces by way of national guidance sets out adequately what children actually need.
I also think that from my point of view, the way that the debate is framed is very much looking at the SEN part of SEND and not the D part.
Yeah.
Because there's some reference, for example, to the fact that if you have a child who is deaf, you might need input from a qualified teacher of the deaf. But there doesn't seem to me to be a recognition of the fact that there are children who don't have what might be in the high needs category, but who are disabled, as well as having special educational needs. That means that what is reasonable for them will be sort of a connection of all of these things put together. And then, you know, what impact that will have. For example, Fiona, what you said about what does it mean by full? What does reasonable adjustments mean? So I hope that there will be that sort of intersectionality will be addressed, so
Yeah.
that those children do not get left out.
Well, I mean, the thing is, I've very rarely met any children who meet the D rather than meet the SEN at the same time. So, I mean, I think although that is technically possible, I have rarely encountered children for whom that is the case, but one would assume that there would be more of those children under the move. I also think that one of the things they're saying is the EHRC are going to have to rewrite their technical adjustments. And, they're very much leaving it to the Equality and Human Rights Commission to do this piece of work. I mean, some of us might say, who have been looking at goods and services and the transgender issues, that the Equality and Human Rights Commission has got quite a lot on his plate. But it's going to have to rewrite it to basically say schools are going to have to deliver a lot more than they do at the moment by whatever reasonable adjustment. I think that's probably where the impetus and the push is coming from.
Yeah. We've had a question, I think, that follows on from your talk, Joe, just in relation to where schools sit, where they're responsible for the provision up to the highest level. Is there going to be an encouragement on schools or is there an incentive for schools to push children up the chain to avoid direct responsibility?
Yes. There is ultimately, if funding doesn't follow, or if funding is linked to the pupil, then there is always going to be a financial incentive to emphasize then the pupil's needs, and the only way to do that is to show that it can't be met for the universal offer. And I think lurking behind that question is a more fundamental essay question that the white paper slightly evades, is of what model do we want? Do we want Children and Families Act model where there's very heavy parental rights, but that means that the budget holder isn't the same person as the decision maker? Or do we want an NHS model where the decision maker and the budget holder are the same person? And unless you're prepared to come down one side of that line, you're going to end up in court. And I think that's where I don't think the DfE have fully confronted that question yet.
Well, I think the DfE are of the view that everything will be sort of rainbows and lollipops and everyone will get on. I mean, look, in the vast majority of cases, this is going to work well. And the idea of having more inclusion is sensible. I mean, it's a return to the 2001 Act and the incentives behind the Act in 2001, which somewhat got lost in the post. And one of the reasons a lot of people say is because the creation of academy trusts and the nature of the way that some academy trusts work were inimical to the idea of reasonable adjustments. So if you come from a particular perspective, that's what you're saying. I don't think anyone is against the principles, but like everything, this is a way to save a lot of money. We have to recognise that. We also have to recognise that we can't afford the system in the way that it currently operates. The question is whether the balance has been struck in this case to please most of the people.
And that seems like a...
Oh, sorry.
Go on.
I was going to say, I absolutely agree, Fiona. I although we have been focusing on the potential tensions and challenges, I think there is a lot to endorse in this programme. My concern is that if you're going to go part the way, you're still going to end up with conflict and tension.
Yes, particularly in a system which, as you identify, Joe, allows conflict or encourages conflict as a way to get more money.
And I think, sort of as my final reflection, that when I advise schools in, for example, discrimination claims and the child is still on roll, the focus of the school is on trying as much as they can to preserve the relationship with the parents so that the child does not lose out. And I do see in the creation of more opportunities for conflict, that consideration becoming increasingly more difficult and potentially forcing schools into agreeing settlements which actually undercut the purpose of these reforms just to get the parents' issue away. For example, if they threaten to sue, making a reasonable adjustment to compromise that claim that then puts them in difficulty. So I think that is an unfortunate, I think, consequence of of this change, which needs to be reflected on by the policymakers. And I'm glad I'm not one of them, because it's a hard process, this.
Yeah, I do think, however, given the amount of money and the Treasury impetus to save it, this will go through, or they will try and make it go through. Right.
On that note, that sounds like a good place to end. So thanks for all your reflections, thanks to the speakers, and thanks to you all for attending. As I mentioned at the start, you'll get the slides and a recording, or a link to the recording, shortly. And thank you everyone for attending.